So good day classmates and good day Judge. I am Jordan CUETO and today I will discuss Canon 22. A lawyer shall withdraw his services only for good cause and upon notice appropriate in the circumstances. Specifically, Rule 22.01, how a lawyer can withdraw his services. So ano yung dynamics for the withdrawal of the lawyer from the case. So first thing, kailangan natin maintindihan muna what is the concept of appearance when used in a legal setting. So appearance is the act of submitting or presenting oneself to the court, either as plaintiff or defendant, personally or to counsel. So we all know, we have discussed that a person can appear in court even without counsel. Pero it is highly recommended that he appears or she appears with a legal counsel, and we will go further on that idea kung bakit ba recommended na laging merong legal counsel. Plaintiff appears by filing a complaint, defendant appears when he files an answer. So this is most of the time for civil cases. This is applicable. Essentially, the act of submitting your own person or subjecting your own person, the juridical person, to the jurisdiction of the courts. Rationale of the appearance concept. So, by appearing, the client acknowledges that the court's jurisdiction over his person. So, ina-acknowledge ni client, ina-acknowledge ni person yung jurisdiction ng court over him or over her. So, ito naman is regarding lang dun sa case na nakahain. So, again, alam naman natin that the judiciary can only act if there is a case. So, itong jurisdiction na to over the person is only applicable in that certain case na nag-appear si person. This means that he agrees to be bound by the judgment of the court without prejudice to his right to appeal. So, ito, by appearing in court, you essentially agree to the judgment of the court. But it doesn't mean na yung right mo for appeal is immediately non-existent. So, yes, you submit yourself, you agree to the judgment of the court, but you still have the power to appeal the case if ever man merong disagreement or if you want to pursue the case further. Therefore, a legal counsel is a crucial part of any appearance by any person in court to give him or her a fair trial, as well as to allow the judicial system to optimize the pursuit for truth and justice. So first, kailangan ng legal counsel, syempre, para equip si client ng proper legal defense pag nag-appear siya sa court. As well as, para din ma-optimize yung judicial system para ma-improve. Kasi if we only allow, but if we only use yung mga specific, yung person mismo in the litigations, then mawawala na yung expertise ng lawyer. So, kaya laging recommended na merong lawyer when it comes to appearance. Kasi lawyers, when they argue, when they present their cases, then ultimately, through the process of argument, nagkakaroon tayo ng better jurisprudence. Nagkakaroon tayo ng better interpretations of the law. Then ultimately, na-improve yung judicial system. To sum it up, the attorney-client relationship is a foundation of the judicial system. So, yeah, si attorney and si client is an integral part of the judicial system. Good defendant argument plus good plaintiff argument equals better jurisprudence. So by allowing lawyers to argue, by allowing lawyers to present their ideas and to form logical interpretations of the law for through litigations or through appearing in court, then as time goes by, nagiging better si jurisprudence kasi nagkakaroon tayo ng better understanding of the law, better interpretations through time. Challenge the system to make it better. Essentially, yun yung idea. So, challenge ng lawyers yung system, yung judicial system, through arguments, through litigations, and then ultimately it gets better through time. So now we go to the termination of attorney and client relationship. In general, the client can always withdraw from the attorney-client relationship. The same is not true for the lawyer. So, absolute yung power ni client na mag-withdraw from the attorney-client relationship. Anytime he or she wants, pwede siyang umalis, pwede siyang maghanap ng bagong counsel. The same is not true if lawyer ka. So, hindi ka pwedeng basta-basta mag-withdraw, hindi ka pwede basta-basta umatras from handling the case. An attorney may retire from a case only. So, dalawa lang to. Written consent of the client or by permission of the court. So, without any of these two, hindi naman kailangan pareho, pero kailangan at least isa meron. If wala, then the withdrawal of the attorney is not proper. And he can face reprimands. So, situations. Ito na yung situations when a lawyer can withdraw or justifiable yung withdrawal niya from a case. Rule 22.01. The client pursues an illegal or immoral course of conduct. The client insists to pursue acts that violate the canons and rules. Inability of the lawyer to work with co-counsel. Mental and physical inability. Non-payment of attorney's fees. Lawyer is elected or appointed to public office. And then there are other circumstances. So, client pursuing an illegal or immoral course of conduct. Client insists upon an unjust or immoral course of conduct. In cases like this, a lawyer can withdraw his services given that he notified his client. So, if si client nag-insist na that you do something unlawful, that you do something unjust or immoral, then you can withdraw from the case given that you have notified the client. So, even if unlawful yung request niya, even if he is committing illegal or immoral courses to pursue the case, you still have to give a notification to allow him the proper time, to allow him the chance to find a new counsel. So that's just part of the due process. Client insists that the lawyer pursue acts that violate the canons and rules. So we all know that we must uphold the canons and the rules at all times. So if the client insists on the lawyer that he breaks the canons and the rules, for example, gusto niyang awayin ni lawyer si judge, or gusto niyang murahin ni lawyer si judge, then the lawyer can withdraw from the case. That is a ground. If the client insists in doing otherwise, a lawyer can freely terminate their relation. If the client is insistent, then the lawyer can freely terminate the relation. Again, the approval of the court and the written or the written consent of the client must still be secured, even in these situations. Inability of lawyer to work with co-counsel. So this exists if there are multiple counsel in an ongoing case. So arises if the client has two or more retained lawyers and said lawyers could not get along. The lawyer whose opinion is not sustained by the client may withdraw. So kung ano yung opinion na hindi sustain ni client, then the lawyer can withdraw. The lawyer na hindi sustain yung opinion can also withdraw. In cases of more than two counsels, so if there are two or more, like 3, 4, 5, then a lead counsel is proper. The lead counsel's opinion prevails. So dito hindi na masyadong material si opinion ni client, kung kanino mag-agree si client. Kung ano yung sabihin ni lead counsel, yun yung magpe-prevail. Even if agree si client kay attorney number 3, pero sabi ni lead counsel, ito tayo, then the lead counsel will prevail. I find this rule not that rigid kasi meron ding jurisprudence na nagpapakita na minor disagreements is not a ground for the withdrawal of the lawyer. So, I haven't, hindi ko nalagay yung case in this PowerPoint, pero I'll try to share it later in the class. Pero meron yan. So, hindi rin pwedeng minor disagreements is mag-withdraw na si lawyer. So, kailangan detrimental if the disagreement between the counsel is already detrimental to the proceeding of the case, then yun yung pwedeng mag-withdraw si lawyer. If hindi na nagpo-progress in case because of the disagreement, then the lawyer can withdraw. But minor disagreements, not so much. Mental and physical inability, so self-explanatory. So after the services have been engaged, and the counselor becomes mentally or physically unable to perform the duty as a lawyer, as a counsel, then the lawyer can withdraw from the case. For example, the lawyer is suffering from an incurable disease na kailangan dun muna siya mag-focus, and he cannot perform his duties as a lawyer, then the lawyer can be justified to withdraw from the case. If it is temporary, then a suspension of services is also possible. So, if the inability is only temporary, then suspension is okay. Insanity of the attorney immediately terminates the relation of attorney and client. So, if insanity has been proven on the side of the counsel, on the side of the attorney, then there is no more need for the processing or the approval of the court. If proven naman na insane, then immediately terminated na si attorney and client relationship. Client deliberately fails to pay attorney's fees. So this is integral. This is integral in the practice of the profession. So the attorney's fee is the symbol of the relationship between attorney and client. It is the right of the lawyer to demand payment. However, an attorney cannot withdraw if the client disagrees with him or her regarding an increase in the agreed fees. So, if mag-request na increase ng fee si lawyer, then and the client disagrees, that is not a ground for the withdrawal of the counsel. For an example case, Arsa versus National Bank, 62 fee 570. So, being an attorney is not only being done as an agent of the court. It is also a profession. So it's a given that there should be a fee for the services that will be rendered. Not only because it is just, but because not asking for an attorney's fee is ultimately detrimental to the whole profession. So imagine if majority of the lawyers do not ask for payment for the fees, then the profession itself will deteriorate. The lawyers will go into poverty. The lawyers will be unable to live because the practice of law is a profession. It's a livelihood. Election or appointment. If the existing lawyer, the lawyer has been appointed in a public position that under the law is incompatible with the practice of the law, then the relationship between attorney and client automatically terminates. So, no more need for the approval or no more need for processing. If the lawyer accepts the appointment and the appointment is incompatible with the practice of law, then the relationship automatically terminates. For example, the lawyer was appointed as a judge, then yung clients na hawak niya will be not terminated, but yung clients na hawak niya and the attorney-client relationship that he has with them will be terminated. However, if the position allows for practice of the law, hindi pa rin siya absolute, hindi pa rin na pwedeng hawakan lahat ng cases. The lawyer should use his discretion to determine whether a case has a conflict of interest. So even if the position allows for a practice of the law, the lawyer should still analyze if the case is in conflict with the interests of his position. So if merong conflict of interest dun sa position niya, then he should withdraw because that is the ethical path. He should also not accept cases na magko-conflict in the position that he was given. Other circumstances: disbarment of the lawyer, full termination of the case, death of the client or the attorney. In the instance of the death of the client, the counsel should inform the court immediately. And then the attorney and client relationship will be terminated. Death of the attorney, however, is not immediately a cause for the attorney-client relationship termination, especially if a law firm is involved. So if the client has a law firm hired, or if the law firm itself is the official counsel in the contract, then the death of the lawyer does not immediately terminate the attorney-client relationship because there is still a presence of the firm. On the other side, the dissolution of the firm does not also immediately terminate the attorney-client relationship. So it doesn't mean that if the law firm has been unable to perform, then if it has been dissolved, it does not immediately terminate the attorney-client relationship. So there should still be a process for the withdrawal of the counsel. Again, subject to the approval of the court or the written consent of the client. If the client naman, in the instance naman dissolves the law firm and the client withdraws from the relationship, then that is absolute. In summary, attorney-client relationship can be terminated through the withdrawal of the lawyer if it's in conflict with any of the following: the law, the canon, and the rules. So if the relationship is in conflict, if the attorney-client relationship is in conflict with the law, the canon, and the rules, then it can be a ground for the withdrawal of the counsel, and thus the termination of the attorney-client relationship in terms of appearing in court. That's all. Thank you. For the source, the book that was used in this discussion is Legal and Judicial Ethics by Ernesto Pineda. That is all, guys. Thank you and keep safe.